Welcome to IP Concerns Deep Dive, the podcast version of our IP Concerns blog from Cascade Law Group. Here, we unpack intellectual property related, real business and brand protection topics in a way that actually makes sense, no legal experience required.
Have you ever found yourself just endlessly scrolling through your phone late at night, watching someone frantically slice open like a literal mountain of cardboard boxes?
Oh yeah, the classic unboxing haul.
Yeah.
It's practically its own genre of entertainment now.
Right. You know the exact vibe I'm talking about. There's this upbeat background track, and a creator is sitting on their bedroom floor holding up a pair of, pristine suede boots, and they lean right into the microphone to whisper about this unbelievable retail alternative they just scored. It's omnipresent right now.
It really is. I mean, our digital feeds are completely saturated with creators detailing their latest budget-friendly retail conquests.
Exactly. And there's this one specific word that anchors almost every single one of those videos. A term that has honestly fundamentally rewired how we talk about consumer goods.
I know exactly what word you're going to say. You're talking about the dupe.
The dupe. Yes, it's everywhere.
It is. And it's evolved into this incredibly dominant economic force.
And that evolution is what's so fascinating to me. Because if you rewind the clock back to, the early 2000s, the concept of buying a knockoff carried a pretty serious stigma.
Oh, 100%. It was a secret. You kept it to yourself.
Right. You'd think of those hush transactions on Canal Street, buying a fake luxury handbag out of the trunk of a car.
Yeah, and then spending the rest of the year just praying no one noticed that the stitching was frayed. Or that the metal clasp was made of cheap tin.
Exactly. The imitation was something you actively hid, but now...
Well, the psychology driving the modern consumer has completely shifted away from that shame. Today, finding a high-quality imitation isn't a secret at all.
It's like a badge of honor, right?
Exactly. It's a broadcasted badge of honor. The modern shopper views themselves as savvy. They're someone who has successfully bypassed this traditional inflated retail system.
Right. They aren't looking for a cheap knockoff that falls apart in a week. That's a huge distinction.
It is. They are hunting for a product that delivers the identical aesthetic, like the exact same visual status of a luxury brand, but without the luxury markup.
Yeah.
And that psychological shift, it's transformed the dupe from a shady back alley transaction into a multi-billion-dollar corporate strategy.
It's insane to think about. Entire supply chains and business models are engineered around this one specific consumer desire now.
Absolutely.
Which brings us to the core objective of our exploration today, because while the internet is out there throwing a parade for these budget-friendly finds, there's a really harsh legal reality brewing just beneath the surface of all those viral videos.
A very harsh reality.
Right. So today we're looking past the TikTok trends, and we're going to examine what happens when this entire culture gets dragged into a federal courtroom.
And it is getting dragged there.
It is. We're focusing on this pivotal conflict currently shaking the retail industry. It's the lawsuit between Deckers Outdoor Corporation and Quince Design, Inc.
It's a fascinating case. We're going to break down the mechanics of design patents,
yes,
the legal architecture of brand imitation, and, well, why this golden era of the dupe might be hurtling toward a massive systemic legal reckoning.
Yeah, a reckoning that could permanently rewrite how products are conceptualized and marketed in the digital age. So let's set the stage here and look at the actual contenders in this specific battle.
Let's do it.
On one side, serving as the plaintiff, we have Deckers. Now, even if that corporate name doesn't ring a bell for you immediately, their flagship brand is undeniable. They are the parent company behind UGG.
Right. And when you're analyzing UGG's position, you really have to account for the sheer cultural gravity the brand commands.
Oh, it's massive.
It is. They haven't just manufactured footwear. They've engineered this globally recognized, completely ubiquitous silhouette.
Yes, the silhouette.
When you see that specific style of low-cut sheepskin boot, your brain processes the shape long before...
That is so true. You can spot that chunky, cozy silhouette from 50 yards away across a crowded airport terminal.
Exactly. Deckers has invested decades, alongside hundreds of millions of dollars in marketing, R&D, quality control, just to cement that specific physical form into the public consciousness.
It operates as a status symbol, a comfort staple, and a cultural touchstone all at once. So we have the plaintiff defending decades of this heritage, and then on the other side we have Quince standing as the defendant.
Right, and Quince operates on what the industry calls a direct-to-consumer, or D2C model.
Which has become incredibly popular lately.
Oh, incredibly. They've built their whole reputation around this philosophy that they market as transparent pricing.
Transparent pricing. Okay, break that down for us. What does that actually mean in practice?
Well, in a traditional retail supply chain, a product moves from the manufacturer to a wholesaler, then to a distributor, and finally to a brick-and-mortar storefront.
Right, a lot of steps.
Exactly. And each step adds a margin, which inflates the final price tag for the consumer. Quince's model bypasses those traditional middlemen entirely.
Oh, I see.
But shipping directly from the factory floors straight to the consumer's doorstep, they argue that they can offer premium materials at a fraction of the traditional cost.
Yeah, you go to their website and they literally lay out the economics for you. They have these graphics comparing their manufacturing costs and minor markups against the huge traditional retail markup.
It's very effective marketing.
It really is. It feels highly democratic. It gives you the impression that, like, the curtain has been pulled back, exposing the fashion industry's greed and offering you a smarter way to buy.
It taps perfectly into that consumer desire we talked about, the desire to outsmart the system. It's a highly sophisticated strategy to capture shoppers who want premium aesthetics without paying for a brand's overhead.
But, and here's where the friction starts, we have to look at the specific products Quince is offering. Deckers analyzed Quince's lineup, particularly their Australian shearling boots, and they filed a massive lawsuit.
Right, because Deckers alleges these boots aren't merely, participating in a broader winter footwear trend.
No, they claim these are actionable, illegal copies of two specific, highly lucrative UGG models. We're talking about the Classic Ultra Mini and the Tasman slipper.
And it's important to note that those two specific silhouettes happen to be the most viral, sought-after designs in the current UGG portfolio.
Exactly. They are everywhere. And now, I want to push back on this D2C philosophy for a second.
Okay, go for it.
Because when I look at a business model championing transparent pricing, I start to wonder if that marketing angle occasionally serves as just a convenient smokescreen.
A smokescreen for what?
Like, does transparent pricing sometimes just mean a company skipped the arduous, really expensive process of research and design?
Oh, that tension right there. That is the central artery of this entire legal debate.
Really? So Deckers is making that exact point?
Absolutely.
Yeah.
A heritage company like Deckers argues precisely that. Their stance is that Quince can only offer lower prices because they didn't have to spend 5 years conceptualizing the distinct asymmetrical collar of the Tasman slipper.
Right. They didn't have to pay for that R&D.
Exactly. They didn't have to run focus groups, test prototypes, fail multiple times, and take on the massive initial financial risk of launching an untested shape into the market.
Yeah, from Deckers' perspective, the imitator simply waits for the pioneer to do all the heavy lifting. They identify what succeeds, and then they just send a 3D scan straight to an overseas manufacturer.
Which completely undercuts the original creator.
It really does. It's like, okay, it's like someone watching you spend 3 years writing a novel, right? You wait for it to hit the bestseller list, and then they take your exact manuscript, print it on slightly cheaper paper, and then boast about their efficient printing costs.
That's a great analogy.
The hardest part, the actual creation was entirely bypassed.
Yeah.
But just to play devil's advocate for a second, fashion is inherently iterative, right? I mean, when a low-cut shearling boot becomes the standard uniform for winter, shouldn't competitors be allowed to manufacture their own versions of a seasonal staple?
And the defense leans heavily into that exact argument. They frame their operations around the democratization of fashion.
Right, bringing it to the masses.
Exactly. They argue that no single entity can monopolize the basic concept of a slip-on winter shoe. They position themselves as providing a vital alternative for consumers who are priced out of the premium market.
Which sounds noble on paper.
It does. But this is where intellectual property law steps in to draw a hard boundary. The courts have to differentiate between drawing inspiration from a macro trend and executing a precision copy of a protected proprietary design.
Okay, so how does a company like Deckers actually enforce that boundary? Because we need to transition here from the brands themselves to the specific legal architecture that actually governs the shape of a shoe.
Right. To understand the weapon Deckers is deploying here, we first have to clarify why a standard trademark lawsuit would fail.
Yeah, because I think most people equate brand protection entirely with trademarks.
You do.
Like the visible identifiers, right? The Nike swoosh, the signature red sole of a Louboutin, or the actual letters UGG stitched onto a keel tag.
Exactly. Trademarks are vital, but their legal function is actually very narrowly defined. They exist to prevent consumer confusion regarding the origin of the product.
Meaning who actually made it.
Right. So if a counterfeit operation sews an UGG tag onto a boot manufactured in a basement, that's a straightforward trademark violation. The consumer is being actively deceived about who made the shoe.
But modern manufacturing and modern marketing are far too sophisticated for that now. Quince isn't slapping an UGG label on their boots.
Not at all.
They are clearly packaging and branding them as Quince products.
And therefore, the trademark claim is completely neutralized. The imitator bypasses the trademark by openly stating, hey, we're a different company. We've just engineered a product that looks virtually identical to the one you want.
Which is wild, so they just sidestep it.
They do. And this forces the original creator to rely on a different and arguably much more potent mechanism. The design patent.
Okay, I really want to spend some time breaking down the design patent because it operates very differently than what I think people typically envision when they hear the word patent.
Yes, there's a big misconception there.
Right, because we usually think of utility patents like protecting the internal mechanism of an engine or the chemical compound of a pharmaceutical drug.
Exactly. A utility patent protects how something functions. A design patent, conversely, exclusively protects the ornamental look of a functional item.
Ornamental look.
Right. It covers the visual characteristics, the surface ornamentation, the specific geometric configuration, or any combination of those visual elements.
Okay, so let's translate ornamental look into the physical reality of a shoe. Because we aren't talking about the fact that the boot keeps your foot warm, right? That's the function.
Correct. The warmth is utility.
So we're talking about, what, the exact millimeter depth of the heel curve? The specific angle where the suede meets the sole on the classic Ultra Mini?
Exactly that.
Or like the braided, contrasting stitch pattern bordering the collar of the Tasman slipper?
You've got it. It's the physical embodiment of the designer's aesthetic choices. A boot functions perfectly well as a boot, regardless of whether the collar is cut at a 30-degree angle or a 45-degree angle.
Right, it still goes on your foot.
Exactly. But if the designer chooses the 30-degree angle and patents it, that specific visual expression becomes protected property.
That is so interesting. You know, the most accurate analogy I can conceptualize for this is think of a sports car driving down a dark street.
Okay, I like where this is going.
If you see the silhouette of a Porsche 911 at midnight, just illuminated by streetlights, you don't need to see the emblem on the hood.
No, you don't.
You don't even need to hear the engine. Just the sloping curve of the roofline and the specific oval shape of the headlights tell you exactly what it is.
Exactly.
The shape itself is the brand identity.
That analogy perfectly encapsulates the modern retail environment. For many consumers today, the silhouette has actually superseded the logo in terms of cultural value.
Wow. Superseded the logo.
Yeah. Historically, visible branding was the primary driver of status. You wanted the big logo. But today, the aesthetic shape carries the premium. Consumers want the visual recognition of that iconic profile without necessarily needing the branded tag attached to it.
They want the aesthetic association without the financial premium.
Precisely.
But here's my question. If Deckers holds these design patents protecting their iconic silhouettes, how do they actually prove infringement in a federal court?
It's a rigorous process.
Because it's not as simple as holding up two shoes to a judge and saying, hey, look at them, right?
Yeah.
There has to be a specific legal threshold to cross.
There is. And that threshold is defined by a legal precedent known as the ordinary observer test.
The ordinary observer test. Okay.
Yes. It is the definitive standard courts use to determine if a design patent has been violated.
So what are the actual mechanics of that test? Like, how does a judge or a jury actually apply it in a courtroom?
The test hinges on a very specific hypothetical scenario. It asks this. If an ordinary observer, meaning a standard, everyday purchaser of these items, not some industry expert equipped with a magnifying glass.
Right, just a regular person.
Exactly. If that regular person were to look at the two designs, would they find them substantially the same?
Substantially the same. That's the key phrase.
It is. If the resemblance is strong enough to deceive that ordinary observer, inducing them to purchase one, supposing it to be the other, then infringement has occurred.
Okay, let's put this into practice. Let's say I'm just a regular shopper, right? And I'm scrolling through an Instagram feed while I'm riding the subway.
A very common scenario.
My brain isn't conducting a forensic analysis of thread counts. I'm processing an overall visual gestalt.
Yeah.
I see a suede, ankle-height boot with a shearling lining and a distinct asymmetrical top.
Right.
My brain conflates the two images almost instantaneously because I'm processing the dominant features, not the microscopic variations.
And the law is actually structured to reflect that exact cognitive reality.
Really?
Yes. Humans process visual information holistically. The courts don't demand an identical atom-for-atom recreation to prove infringement. They focus on that overarching visual impression you just described.
But doesn't this introduce a profound level of subjectivity into the legal system?
Oh, absolutely.
Because when you look at modern global supply chains, overseas factories possess the technology to 3D scan an object and reverse engineer a silhouette with laser precision.
Down to the micrometer.
Right. They can manipulate the design by a fraction of a millimeter. So how does a court objectively define substantially the same when the differences are intentionally microscopic?
That subjectivity turns the courtroom into an intense battleground of perspective.
I can imagine.
Defense attorneys will isolate every minute discrepancy. They'll point out a slightly modified tread pattern, a different dye process for the suede, or a millimeter shift in the heel tab, arguing these variations create a fundamentally distinct product.
Basically saying, look, it's not the same shoe.
Exactly. While the plaintiff's counsel will constantly push the jury to zoom out, urging them to rely on their initial, holistic visual reaction.
And here is where the logic of the ordinary observer test feels a bit paradoxical to me in the current market.
How so?
Let's look at the actual behavior of a shopper in the dupe era. When someone opens TikTok or Google and types in, like, cheaper alternative to UGG Tasman, they are actively searching for a different company.
Yes, they are.
They are purposefully seeking the non-UGG product. So at the point of sale, they aren't actually being deceived. They know they are buying a Quince boot. So if the consumer isn't being tricked, does that unravel the plaintiff's argument under the ordinary observer test?
You've identified the most complex legal friction point in this entire phenomenon.
Really? Because it seems like a huge loophole.
It does seem like one.
Ah.
Historically, the ordinary observer test operated on the assumption of deception, that the buyer was confused and tricked into buying the wrong item.
Like the Canal Street handbag.
Exactly. However, jurisprudence regarding design patents has evolved. Courts now recognize that the protection applies to the design itself as a piece of intellectual property, completely independent of point-of-sale confusion.
Wait, really?
Yes. Even if a consumer is fully aware they are purchasing a Quince product, if the physical architecture of that product infringes upon the patented ornamental look owned by Deckers, the infringement stands.
Wow.
The theft is of the geometry, not necessarily of the customer's intent.
That is a vital distinction. The property isn't just the customer's loyalty, it's the physical geometry of the shoe.
Exactly.
And this leads to what I find to be the most self-sabotaging element of modern retail. Because if the legal standard relies on proving these items look substantially the same, brands are currently building their own executioners through their marketing department.
No, they absolutely are.
Let's examine the mechanics of this social media trap.
It's a phenomenon driven entirely by the structural demands of digital algorithms. In the context of the ordinary observer test, social media provides plaintiffs with an overwhelming, publicly accessible archive of evidence.
Walk us through the mechanism of this digital paper trail. How does an algorithmically driven marketing strategy actually translate into federal evidence?
Well, consider how modern commerce operates. Visibility is dictated by search engine optimization, hashtag aggregation, and keyword bidding.
You have to play the algorithms game.
Exactly. To capture market share, an alternative brand needs to intercept the search traffic of the dominant brand. If thousands of people are searching for UGG Ultra Mini, a competitor wants their product to appear in those exact search results.
Right, they want to piggyback on that hype.
Yes. And to achieve this, brands, influencers, and affiliates frequently use comparative language. They tag posts with hashtag UG Dupe, or openly state, this is the exact same shape for half the price.
So by attempting to hijack the search intent of the original brand, they are inadvertently drafting a legal confession.
That's exactly what they're doing.
The brand's marketing arm is basically shouting into the digital void, look at our product. It is visually indistinguishable from the patented competitor.
Precisely. The very language engineered to optimize search results and drive immediate sales acts as a devastating admission of liability.
That is why
We often visualize intellectual property disputes as these dry, technical affairs involving blueprints and patent filings. But the reality of modern litigation is that a brand's social media output is intensely scrutinized.
So bad.
A viral comparison video, especially one heavily promoted or sponsored by the imitator brand, serves as compelling proof that the ordinary observer finds the product substantially the same.
I'm just picturing a social media manager celebrating a massive spike in engagement. They hit the right keyword, the post goes viral, the inventory sells out, and they think they've executed a flawless marketing campaign.
Right. Popping champagne in the office.
Exactly. Meanwhile, opposing legal counsel is systematically archiving every single one of those posts, taking screenshots of the captions and presenting them to a judge as Exhibit A.
It happens more than you'd think.
The brand has essentially paid for the advertising to prove the plaintiff's case.
It exposes a dangerous disconnect within corporate structures. The marketing department operates on a metric of speed, engagement, and algorithmic visibility, while the legal reality operates on enduring statutes of intellectual property.
They aren't talking to each other.
Not at all. The pursuit of viral traction blinds these companies to the profound legal exposure they are engineering for themselves.
Okay, but if the marketing strategy is this inherently risky and design patents hold this much structural power, why is the market still flooded with these products?
That's the big question.
Right. What gives a manufacturer the confidence to tool a factory line for an identical silhouette in the first place? To answer that, we really have to dismantle a pervasive piece of industry folklore.
Oh, yes. We need to talk about the death of the one-inch rule.
The one-inch rule. This concept, it operates as this psychological safety net for designers and manufacturers across the globe.
It's an ingrained, almost mythical belief system within the retail sector.
I've heard numerous variations of this over the years. Some designers refer to it as the 10% fallacy.
Yep, that's another name for it.
The core belief is that if you take an existing patented product and alter just 10% of its physical design or modify a specific element by a single inch, you have legally inoculated yourself against infringement.
That's the myth, yes.
They believe that changing the color of the stitching, widening the toe box by a fraction, or swapping a metal zipper for a plastic one magically transforms the item into a distinct original work.
It's an incredibly persistent myth. And from a legal standpoint, it is entirely fabricated.
Entirely fabricated.
Completely. There is no federal statute, no established legal precedent, and no mathematical formula that quantifies design patent infringement by percentages or inches.
So it's just made up.
Yes. A court does not process a design through an algorithm to determine if 11% of the surface area was modified.
And that reminds me of the mentality behind like software code theft or architectural plagiarism.
Oh, that's a good comparison.
Yeah, right. Because you can't take an architect's blueprint for a highly unique custom home, change the font on the title block, swap out the brass doorknobs for brushed nickel, and then claim you designed the house from scratch.
You definitely cannot.
The foundational structure, the core intellectual property, remains entirely lifted. A judge won't pull out a ruler and say, well, the hallway's 1 inch wider, so it's a novel design. The overarching composition is clearly stolen.
And that's precisely how the courts view it for physical products, too. The Deckers case acts as a prominent reinforcement of this reality.
Because it all comes back to the ordinary observer.
Exactly. The judiciary relies on the overall visual impression derived from that test. If the holistic aesthetic of the new shoe mirrors the patented shoe, the microscopic adjustments are legally irrelevant.
You cannot hide behind a modified zipper.
You can't. Or a slightly altered tread pattern. If the recognizable overarching geometry of the product is substantially the same, you are liable.
This realization carries massive implications for the retail sector. It effectively signals that dupe culture, as a foundational business defense, is legally defunct.
It really is.
A brand cannot stand before a federal judge and use the term dupe as a shield, claiming their fractional modifications absolve them of infringement.
No, it strips away that false sense of security entirely. If a product's commercial success relies entirely on it looking like a recognizable imitation to the consumer, that exact visual similarity transforms it into a profound legal liability.
Which changes everything.
It does. The industry can no longer operate under the assumption that minor tweaks provide immunity. They are operating directly within the crosshairs of federal intellectual property litigation.
Man, we've covered significant territory today.
We really have.
We analyzed the psychological shift in consumer behavior, detailed the specific conflict between Deckers and Quince, unpacked the mechanics of design patents versus trademarks, explored the paradox of the ordinary observer test.
And outline the algorithmic traps of digital marketing.
Yes, and dismantled the persistent myth of the one-inch rule. So let's pivot from diagnosing the structural vulnerabilities of the retail market to establishing a practical framework for brand protection.
That's the most important part.
What actionable insights can businesses actually extract from this case study?
Well, we can consolidate the lessons from the Deckers versus Quince litigation into 3 fundamental pillars of modern brand defense.
Okay, let's outline those pillars. Pillar number 1, the structural reality of intellectual property.
Right.
We've clearly established that relying exclusively on trademark protection is a huge vulnerability. When competitors simply strip away the logo and replicate the form, trademarks offer minimal defense.
Minimal to none. Securing robust design patents is the most critical, highly effective strategy for protecting a unique physical product in the modern market.
So if your brand generates value through a specific silhouette, you must legally lock down that geometry.
Absolutely. Which brings us to pillar number 2, marketing liabilities.
Oh, yes. Brands must maintain strict oversight of their digital footprint. Utilizing same as marketing or optimizing search traffic around a competitor's patented design is just a direct invitation for litigation.
Exactly. The algorithm might reward the comparison in the short term, but the resulting digital paper trail is permanent, and it's legally damning.
And pillar number 3, the absolute eradication of the one-inch rule.
Yes. Mathematical percentages and fractional alterations provide zero legal cover. The courts are governed by the overall visual impression.
If an ordinary consumer visually conflates your product with a patented design, the fractional differences will not protect you.
They won't.
So, I urge you to look critically at the operations you run or the brands you invest in. Is the foundation built on genuine, ground-up innovation? Or is the entire revenue stream reliant on a slightly altered silhouette, just hoping the original creator doesn't file a brief?
It requires a rigorous, honest internal audit. The prevailing wisdom for any creator or manufacturer in this hyper-accelerated market is the absolute necessity of proactive legal structuring.
Proactive, not reactive.
Exactly. You must secure your design patents long before you launch a product, before it gains viral traction, and certainly before the overseas supply chains begin reverse engineering your work. Operating reactively is no longer a viable strategy.
Right. And, if analyzing these legal thresholds, navigating the complexities of patent filings, and auditing your social media strategy feels a bit overwhelming, you don't have to manage it in isolation.
No, you definitely shouldn't try to navigate this alone.
If you require expert guidance to understand these statutes and ensure your brand's architecture is fully protected, Cascade Law Group is an exceptional resource.
They really are.
They specialize in guiding businesses through these exact intellectual property frameworks. I highly recommend checking out Cascade Law Group's weekly blog and podcast.
That's fantastic material.
It is. It provides continuous, high-level analysis on protecting unique assets and navigating the evolving legal landscape of modern retail. It's truly a fundamental resource for anyone operating a brand today.
Utilizing resources like Cascade Law Group's weekly blog and podcast provides the strategic awareness necessary to prevent your company from becoming the subject of the next major federal lawsuit.
Exactly. All right, let's synthesize everything we've explored during this session.
Let's do it.
We began by observing the chaotic, highly visible world of digital unboxing videos. We traced how a consumer demand for accessible footwear escalated into a high-stakes legal confrontation between Deckers and Quince.
And we learned how the battleground for brand identity has migrated away from standard logos and straight into the three-dimensional geometry of the products themselves.
Right. We exposed how digital algorithms inadvertently weaponize a brand's own marketing against them, and we definitively retired the myth that minor design tweaks offer legal immunity.
It provides a very comprehensive map of the new, highly complex reality of brand protection in an era defined by rapid imitation.
It really does. But before we conclude, there's a fundamental economic question that this entire landscape forces us to consider. Well, if the current global market, driven by aggressive algorithms, rapid manufacturing, and immense consumer demand, continues to disproportionately reward the companies that perfect the imitation rather than those that fund the original research.
Yeah.
What happens to the pipeline of genuine innovation?
That is the big question.
Right. If the dominant business strategy is simply to wait on the sidelines, allowing one pioneer to absorb all the financial and creative risk before copying their silhouette, eventually, who is left to take the risk of pioneering?
It presents a profound structural dilemma for the industry. If the economic ecosystem consistently starves the originators of their return on investment, the overarching well of design and innovation will inevitably run dry.
It's a really complex dynamic to consider the next time a targeted ad offers you a familiar-looking silhouette at a fraction of the cost.
It makes you think twice.
It definitely does. Well, we appreciate you taking the time to navigate these intricate legal and economic frameworks with us today.
Stay analytical, remain aware of the systems driving the market, and ensure your creative output is rigorously protected.
And pay close attention the next time you're evaluating a new retail find. You might just be analyzing the subject of a precedent-setting federal exhibit. See you next time.